Roll call, please.
Mr. Griffith.
Here.
Mr. Haas.
Here.
Ms. Houck. Mrs. McDermott.
Here.
Mr. Perry.
Here.
Mr. McGinley.
Present.
Ms. Radel.
Here.
Ms. Sedman.
Here.
Mr. Schnee. Mr. Urban.
Here. Oh, sorry. Jump.
Mr. Vogt.
Here.
Ms.
On
Houck is
the-
here. She's just in the ladies' room.
On the work session agenda, number 2 has been deleted, and we will have that as part of our session on February 11th. As part of, hopefully, the PennDOT representative will be here, so we'll put those 2 items together in order to prepare for that vote. And number 4, the administrative code, I've talked to Ms. Houck, and that's going to be deleted for this evening. It's real important that if you have any other comments in that regard, please get those to Ms. Houck so that she can have the whole document together. Hopefully, in the future, as we go through it, and Ms. Houck will be back, I'm sure she's probably, we'll have to decide, I think we'll have to do that in sections in order to be able to complete that and not have 1 item or 2 items defeat the whole code. So bearing that in mind, we have a motion to adopt the agenda.
So moved, Mr. Chair.
Mr. Haas, Ms. Sedman, all in favor?
Aye.
Thank you. Mr. Swets?
Thank you, Mr. Chair. In your packet is the monthly budget reports. These reports are for December. Just to give a little bit of background, the county's borrowing was done at the end of November, so you would have seen that money come in November. We approved the $33.3 million. We had $12.2 million of refinancing. That gave the county the $21.1 million. $1.4 million of that went to voting machines, with the rest going to the 911 project. In the December report, you won't see the tran. That'll be in the January report. That'll also be in the general fund. So that whole amount will be in the general fund. The actual piece of the voting machines is in the 265 funds. There was a question on where's the voting machines and what access is needed, and that's Fund 265. So that's where you'll see the $19.8 million. In the packet, again, as I've said before, is the December numbers. We'll be having the hard close in about 2 or 3 weeks as per normal. So you'll see that in the next updated report. So basically you have the December numbers as of now. There's quite a bit encumbered, as accounts payable was very busy as we were transitioning between the end of this year and the end of last year and the beginning of 2020. We also have the treasurer's report, and just take note at the top that we closed out those short-term investment accounts. The one had some interest post after the fact, which we subsequently moved. So that's all I have. Reports were in your packets. If there's anything I have, I'll give it now. If not, I'll have to follow up.
Questions for Mr. Swets?
You said, oh, sorry.
Go ahead.
You said that the voting machines are in 265?
No, I'm sorry. So in the 265 fund, the digital is the 911 digital upgrade.
Right. And what's the voting machine?
The voting machines are not in a separate fund. They're part of the general fund. The
So they-
1.4 million is in the general fund.
So they went to Fund 100?
Correct. Sorry.
What line item were they receipted to?
I'd have to pull it. It was in the 21 million for November. I can pull it for you.
Okay.
Do we have a final cost for the voting machines?
3.6, somewhere around there. I don't have the exact number with me, but somewhere around 3.6
And we
million.
have state contribution will be,
The state contribution would be 60%. So that's how we came up with the 1.4 is the amount that we borrowed.
okay.
And we've applied for that, and we've applied for the federal funds as well.
Correct.
Yes, that's right. So we've made application for those funds, but those funds have not been received.
Correct.
Am I correct in that?
Yeah, all the only money that we've received now is the borrowed money at this point.
Okay.
One other question regarding the voting machines. The HAVA fund, I noticed that had decreased significantly by over 200,000. Was that used toward the voting machines as well?
Yeah, so the HAVA fund is had about, at one point, probably 200,000 a few months ago. Yeah, so if any HAVA funds are related to any voting type of projects. So whether that be we have to fix something to have a building up to compliance, or, but at this point, none of it was used for the voting machines itself. out of the
So-
HAVA fund.
Okay, so the balance that I was looking at, New World, shows less than, it shows that I can't see the 200,000+. I only see maybe like $4,000.
Right, that's what's currently in there, correct.
I can get your report on what the $200,000 was spent.
We should be able to see that.
Well, yeah, I mean, we should see everything.
Okay.
You know, and that's my question is that we got the access, and I'm still unable to break certain areas down further, like drilling into the.
I got your emails. I'm
Okay.
gonna sit down with Budget and Finance today. It was a very busy day getting everything
Sure,
together.
I understand.
But I'll sit down with them again and get you the access you need.
All right, thank you.
Any other questions for Mr. Swets? Thank you.
Sure.
Number 3, discussion regarding the MS4 stormwater program, which we've had a lengthy discussion this evening. Mr. Griffith, you want to respond because you had asked earlier?
Well, the only thing that I think is really important on that stormwater fee issue is that I certainly understand the challenges that the Office of Law have to try and figure out how they're going to file the injunction. I certainly understand that. I spoke to Vito pretty extensively today regarding his concerns about how he's going to proceed with that. So I certainly understand the reason why we postponed it to the work session. I would like to have, if it's appropriate for Mr. DeLuca to tell the council what he's gotten so far, unless he doesn't want to elaborate on it at this moment in the meeting. But I certainly think that it's important to file this injunction. It's important to pass this resolution, get the letters off. The Legislative Committee, of which Harry's the chair, I see on our list, I think we're going to have a very crucial role in trying to get the state legislators and federal legislators in here to try to help the Office of Law get this thing moving along, because I think the Office of Law needs as much help as they can. This, as you know, I certainly understand that's not something that this council or this office, Luzerne County, does on a regular basis. Filing a federal injunction is not child's play. It's not something that you could just drop the paper on the desk without any repercussion. So I think he needs to do his due diligence, and I think we need to give him at least the ability to have time to do that. I think that's really important, because I would rather have time and have it done right than to rush through it and have it done wrong and have a problem. So I would hope that in the next 2 weeks, at our next council meeting, we'd have enough information from the Office of Law to be able to get this on the agenda, get a vote done and move it along, get our letters sent to the appropriate parties, and try to get some relief for the taxpayers in this county. It's very important that we not let this thing dwindle into nothingness. So I appreciate that very much. I appreciate the patience of everybody tonight. It was a good crowd. I appreciate everybody that came out and spoke tonight. And it makes for a long evening, but it's very, very important. And I certainly appreciate council's indulgence in this process. So thank you very much.
Well, I think it was indicated by the email that was sent that you will have a detailed report in 2 weeks, correct?
Yeah, that's what over the past 2 weeks, I went from knowing nothing about the stormwater fee, other than the fact that I was paying it, to bird dog just about every issue, most of the issues that Walter, you had given me quite a few. I think Steve Urban had also mentioned. There was some really creative ideas that I also had to look to. The report that we would give, because it involves obviously potential litigation, we would probably give the details to council in executive session. That's how I perceive, I imagine that would go. But I have heard a lot of talk about injunction. It talks about the Unfunded Mandate Act. I looked at the Unfunded Mandate Act. That only is triggered if the unfunded mandate is over $100 million. I spoke to the legal counsel who represented Westchester, a resident from Westchester County, in I believe it was 2014. She successfully challenged the stormwater fee on a basis that does not exist in Pennsylvania, in our situation. The really interesting follow-up to that story from Westchester County is I believe that once that fee was invalidated because it did not follow the standard uniformity and reasonableness standards that the fees are supposed to follow. I believe the county took over that enforcement of that fee, and now I believe that's under challenge because they were using general fund dollars to fund stormwater management, which did not affect every resident. So you had residents who were not receiving a benefit from their taxpayer dollars who were basically footing the bill for those who were subject to the fee. This fee is in, I've also heard the argument about one government entity charging, if we're just looking at it in terms of Luzerne County being billed by another public entity, which Wyoming Valley Sanitary Authority is a municipal authority under the Pennsylvania Municipal Authorities Act, and they are authorized by state law to administer the stormwater fee. Luzerne County also pays for Wyoming Valley Sanitary Authority fees for treatment of sanitary sewage. That is another fee that we are obligated to pay that has to be based in some reasonable way and has to be applied uniformly. Probably the most creative argument that I got that I'm still following up on was an argument that that the way that Wyoming Valley Sanitary Authority determined the impervious footage versus the property lines, that was supposed to be done by a licensed surveyor. I thought that was an extremely creative approach. I reviewed the Land Surveyors Act. I don't agree. I believe that this type of activity was something that that they were able to do without being licensed Pennsylvania surveyors. But to follow up and to confirm that, I emailed the Pennsylvania Department of State, and that was at least a week ago, I believe, and I still haven't received a response from them. So I really do not mind having anyone who has information that they believe that, because I would have never even considered the approach from the land surveyor perspective. It has involved research into very, very specialized areas of the law, which include obviously federal legislation, state legislation, Municipal Authorities Act, Real Estate Law, Surveyors Act. So, I don't have any issue with, Walter, if you want to keep passing me on the information that you get. We probably spoke on the phone for an hour and a half today and for hours over the last 2 weeks. But we hope to have something within the 2 weeks. I have had extensive conversations with that attorney from Maryland who challenged the fee in Maryland, and so we'll keep you advised, and hopefully by 2 weeks from now we'll be able to have a much better idea.
Thank you. Anyone else on number 3?
So we're just going to move this, Mr.
Excuse me?
McGinley? We're going to move this to the voting session the next time as is, correct? I mean, obviously contingent on.
No, I
what
think
Mr.
at this
DeLuca
point in
says.
time, depending on what the Office of Law tells us, then we'll make a decision where it should be. But I think obviously we need the work that Mr. DeLuca's doing and whoever else is working on that. And so we need to see that, we need to understand and analyze it before we make any final decision.
I think, and I acknowledge that, but I also think there's some components of this that I think we can move forward that are really not controversial. For instance, if you look at the first one, it has to send a letter to the president. I think that's
Well,
very-
I think there's segments of the resolution.
I'm thinking of, if time is really of the essence, I think any additional time we can use to move this forward, I think that might be helpful. I don't know if you'd consider, Walter, maybe splitting the resolution up, moving that to the voting session. Hey, let's send out a resolution of the president, encouraging him for action, and I don't think that could hurt.
No, I agree with you. I think that in itself is a fine First
Non-controversial,
step.
obviously, it lacks teeth, like the bigger part of it. However, I just think it's more notoriety.
It shows your interest and your thoughts on the matter, and I think it doesn't hurt.
I can certainly try and draft something with the help
Well,
of
I
the
think,
Office of Law.
Mr.
for
Doolittle
the
can do that for you.
resolutions for that.
I think, you know, as far as that goes, and I'm not an expert in federal constitutional law when it comes to that, to what, I know President Obama, I believe the executive order that he had issued years ago was basically extending the definition of navigable waters, federal navigable waters. And President Trump's rescinding that executive order at the time was really a nullity because the Sixth Circuit had already been reviewing that expansion of the definition of navigable waters. I don't know what the perception is as far as what the president would actually be able to do, since those regulations by the EPA are basically a manifestation or a result of congressional law. So, but I don't think, obviously, it could hurt. But I also don't know if it really would. Those circumstances, the Obama executive order and President Trump's rescinding that executive order, I don't think that gets us where we're really looking to go, because that was with regard to a very specific part of the regulations where the EPA, you know, by President Trump's position apparently was that they overstepped their bounds, and I believe that was what the subject of the litigation in the Sixth Circuit, which was the EPA extended that definition of navigable waters to include streams and whatever that you couldn't even put a rowboat in. So, but I guess it couldn't hurt.
Well, let's review it, and if it's something that we want to look at, let's do it. Anyone else?
I just want to make some comments, not on this, so, you know, if we're at
Let's
that
do the
point.
public comment,
That's
and
fine.
certainly you'll have an opportunity. Public comment on the work session. Mr. Rabel.
This is just on the work session items, or is this on anything? On anything? Okay. Well, with respect to what was just stated by the solicitor, I've been dealing with this stormwater thing since 2013. And I would make a suggestion about the way the fee is calculated. Because DEP and the EPA give certain suggestions on how the fee should be calculated to entities that are charging this fee. And when I looked at it back in 2014, when Hazleton tried to enforce a stormwater fee, the stormwater calculations did not match up as far as one property owner. If you had two properties that were the same, you had two different calculations. Like you'd have two different fees that were way off. And I couldn't understand why, until I looked at the formula that DEP and EPA put out. And then when you see it, it's kind of like, you know, a jigsaw puzzle. I'm like, why can't DEP and the EPA come up with a formula that actually charges the property owner with the same square footage and the same kind of impervious property or impervious area, the same amount? Because when you're charging for water, like when I was on a water authority, you charge the same amount of money for the same amount of usage. It's, you know, it's just straight one and one. But with the stormwater fee, it's like you're depending on how much rain flow comes to your property, and then you're ascertaining how much impervious area there is, and you're trying to justify what that amount is to be charged. That, I think, is where the challenge can be placed in terms of that aspect. Also, here's another strange thing. because it was brought up in the previous public comment. Harrisburg City is now charging their property owners for the state-owned buildings, including the Capitol and the governor's residence, that they have to pay the rain tax for those buildings, for the state-owned buildings. Talk about insult to injury there. So I think what needs to happen is, as was alluded to previously, that there's 4 times the tax in terms of this rainwater fee. And I think the state needs to coalesce and make it one. If you're going to charge it, charge one time and one time only. Not have every entity charge for every property. It should be just one thing. That's all I'm saying. I think that needs to be alluded to. And Mr. DeLuca, I have a lot of research that I've done since 2013 on this issue. If you and the council would like that, I'll send it to you.
Could I respond to him real quick? Do you mind? I just want to get this aired out.
Go ahead.
First of all, Mr. Abel, I'll give you my contact information. Whatever information you have, I'd be happy to talk to you about, and you could get to me. I'll say, first of all, I alluded to this before, as far as calculation of the fee goes and the way that Wyoming Valley calculated their fee, it was approved by DEP. They submitted their plan, including their what they perceived as their budget for infrastructure improvements and maintenance and all that, also to DEP for approval. As far as the 4 times the tax thing, and I didn't really understand that argument initially when I first started looking at this, and Walter kind of filled me in. It's no different than the fact that Luzerne County is getting charged for sewer, and you're paying your tax dollars to Luzerne County to pay to Wyoming Valley for sewer. You pay sewer at your own property. It's really an analogous situation to that. But I'd be happy, any of the information that you have, I'll sit down with you if you want to sit down and have a coffee, and we'll go through it. I at least have a pretty good grasp of the issues now and what the arguments were for different points of attack, and we could talk about it. But we'll have the full report then in 2 weeks.
Mr. Shiner?
This resolution has several aspects to it. The injunction is just one part. And while I appreciate the work the Office of Law is doing, you haven't really passed this resolution, therefore you haven't authorized them to do one thing yet. You need to pass this resolution to authorize the Office of Law to proceed in checking this whole thing out. Plus, there are other parts of this that can go through that don't require an injunction. Now, I appreciate Mr. DeLuca saying that it's comparable to the sanitary fee that the county pays, but paying the sewer authority for your sewer bill is more like a utility. It's not the same as paying this stormwater fee. I think there is a difference. And we are paying it many times. We're paying it on our own properties, our municipality, the county, the school district, our churches. Now I find out our cemetery. Well, you know, I'm not opposed to paying my fair share, but I'm not about to die paying this tax. And I think you need to do something about it. Now, with the $100 million part for the unfair mandate situation, there's a lot of other communities being hit with this. Why can't we join together, approach it as a class action, and I'm sure it'll go far exceed the $100 million that's required under that act. But the first part of this is to pass the resolution and then go from there on what parts of it are going to be done and followed through on and how. You've got to start the ball rolling. Sitting talking about it week after week, meeting after meeting, is not going to get anything accomplished. Pass the resolution and then see where it goes from there. I think that's the way you need to go. Thank you.
Anyone else? Yes, sir?
would just like to say that it's really, really good thing to see bipartisan at work here. People coming together from 2, 3 different parties and agreeing on this overburdening fee tax. And I think working together, positive results will come of it. Harry Haas has a very good, Councilman Haas, you have a very good poignant point. Go right to the horse. Direct it right to the man, you know. And he addressed it, I think, on Facebook or some reports coming out, he's laxing or withdrawing regulations. So I think it might save a whole lot of money in the long run. That's coming from Ron Knapp.
Anyone else? Council?
If I could, Mr.
Mr.
Chair.
Urban has, no, he has, so we're going to give Mr. Urban first crack here.
All right, as far as certain issues, I mean, I'm assuming that I can speak on the prison contract at this point because it's been approved.
Yes.
Okay. I did not vote in favor of that tonight because I think it still gives away too much. It's going to cost about $500,000 each year, probably for the next 5 years. The strategy behind the union, I think, is a little bit disturbing because this is a brand new council. You know, it puts us in a very precarious situation when you have a contract that's been negotiated for a year, just come to a brand new council, you know, and then you really can't release the terms to the public, or there's reluctance on the county's part to release those terms because of possible, you know, arbitration. I didn't vote for it because, you know, looking at the existing contract, I think there's too many days off. Given right off the bat when you get hired, you get the 12 national holidays, 6 personal days, and 18 sick days a year, which is 30 days out of the gate. After the first year, you get 5 vacation days. Third year, 10 vacation days. Fifth year, 15 vacation days. 10 years, 20 vacation days. 15 years, 28 vacation days. And then after 20 years, it's a half a vacation day for every year thereafter. So let's say you're working for the county for 21 years, you get 65 days off, potentially, in 1 year, which requires a higher number of staff members, because if you get 3 months and a week off, potentially in 1 year, we're paying for a lot of time off. A lot of time off, which requires 322 employees. Now, prior to all of this tonight, I went out and I filed a right to know request to all third-class counties, seeking their salary information. I'm still waiting for like 4 of them or 5 of them. And I know Ms. Radel had given us some information earlier this evening too that she obtained from the union side on some salaries and days. And I think we're more than fair in Luzerne County. We're more than adequate. Lackawanna County, sick time, they get maybe a little bit more. They get 20 days. York gets 12. We get 18. Vacation time, Lackawanna's 25. York's 26. Luzerne's 28. Holidays, we're kind of in the middle of the pack. And obviously the union tends to slaughter their young when it comes to health care. You know, that most senior people pay the least in percentage, and then when the newer union hires come into play, they end up paying 15% in a couple years. And then the most senior people pay 12%. So those that can afford the most pay the least at the top, and the most that basically that can afford to pay the least pay the most. And it's like an upside down pyramid here in Luzerne County. And we're never going to get ahead if we continue this mentality, you know, and taxing one another. All these entities, I mean, we all have to start working together as a community, as a county, to come up with some creative solutions to actually rein in all this expense, you know, and work smarter. Now, you know, over the next 5 years, okay, which actually, since that contract is 5 years, it covers last year and then the 4 years that I'm sitting here on council. So we're going to be at that crossroads again in 4 years. Right after an election, a new contract will probably reappear for the next council in 4 years, or actually in 2 councils from now. You know, so I don't wish that upon anybody. I think management has a responsibility to start those negotiations a lot earlier, so they don't come to a new council within 2 weeks of them taking office, and not being able to look at all the details in depth. And it's time that this council also maybe give some policy and procedure direction to the county manager in the form of a majority. So, he's, obviously, we trust in him to negotiate in good faith and try to get the best bang for the buck. But I think it's a little bit of excessive, I mean, I know most people probably don't get 65 days off a year, potentially, unless you're in a different profession. But, with that being said, you're going to have some hard choices in the next 5 years, or next 4. Some of my colleagues, you're probably going to be facing a, proposed tax increase again. And I am going to be a proponent and a stickler for rules. I'm going to be a proponent to make sure that your I's are dotted, your T's are crossed, that you're following all the rules and the bylaws that we have. I'm going to be looking at other things too, such as how contracts or even checks are being signed, such as the $5 fee. There was a $725,000 check signed or cut out of that $5 fee without coming to council, or the previous council at least, to let them know that that type of money is being expended on a road. When something is sold to a previous council, such as a $2 million match, some of the details were left out. The omission part is what I take issue with. And in order to effectuate a good decision, we need all of those details, Mr. Manager, in the future. Else, it's going to become a crapshoot here at council. And we don't want long meetings. We want everything to be cohesive and a good, solid working relationship between management and council. And with that being said, I mean, I've been going back and looking at a couple different resolutions. There used to be a council member that was appointed to the Diamond City Partnership. That was Harry Haas. We sort of let that one fall by the wayside, and I think that group is still in existence today, so we have to check their bylaws.
Rick Williams took over after me.
He did take over after
he was
you,
the last one.
but nobody's participated in that particular initiative. Mr. McGinley, you and I spoke the other day regarding that you were on the Northeast Behavioral Healthcare Consortium. That resolution was passed 2012-217. That was actually on February 28, 2012, which was technically a one-year appointment. I mean, the language in here is a little bit of a conundrum once again, where it says governing body for a one-year term, but then it also said, to remain effective until December 31st, 2012, or until an appointment is declared declared vacant by county council. Well, if it's a one-year term, it can't be declared vacant. So I think we need to revisit the language on that particular resolution to clean it up. And if we need to reappoint you to that, then let's do it right. That's all I expect this council and this body to do. I'm not my father. I'm a different person. So I do my own thinking. I do my research. And I expect full access to New World, obviously contingent upon any confidential information, mainly the DA forfeiture and seizure account. I don't need to see that. But, Resolution 2014-52 authorized council to have full read-only access. So don't hide any funds because, obviously if I can't get into it, I'm going to come question you on it. I want to see all receipts, anything that's in this system is considered read-only. Anything that's scanned in, invoices, that's all public record that I am eligible to see as an elected public official. And any one of my colleagues can also see that, so if you choose. Some of us want to do the homework and want to do the hard work to make sure that Luzerne County moves forward efficiently, effectively, and at a lower cost. I mean, government shouldn't be this expensive. We're all, hurting one another by passing fees and taxes. Let's work together to lower all of this and make Luzerne County a better place to live and be great.
Mr. Haas?
Yeah, thanks, Mr. Chairman. Going back to Walter's ordinance, and I really appreciate what Brian Shiner just said. I think, this is a work session. I think if we look at this ordinance, I think it is very appropriate to move this forward to a voting session, but with a draft that doesn't necessarily encumber us with action, but it really does permit the Office of Law to further go through and do the research. And if we can look, council, if you look on page 2 of the ordinance, actually top of page 2, it says Luzerne County Council shall draft a letter to the president. Just says we can make a draft, you know, and I think that's very appropriate. If we have this on the voting session next week, we can remand that down to the legislative committee. Legislative committee can begin work on making that draft that reflects on Solicitor DeLuca's research when the time comes. I think it's very appropriate. It does get the ball rolling. Secondly, if we look at the third page, the second section there, it currently reads, the Luzerne County Office of Law is hereby authorized to seek an injunction. Why don't we delete authorized and place in there directed? Again, and Vito's already going to be doing that. He has already begun that
No,
work.
I would just,
Okay, all right, well, that's a negotiable, but authorized, directed, but instead of to seek an injunction, insert to seek information regarding an injunction. Therefore, it doesn't, again, encumber us to action, but it really, it kind of validates what we've been talking about, just like the chairman's picks for the council committees were validated and ratified earlier. I think it's one and the same. And then lastly, a copy of this resolution. I think we can cross out letter, put resolution, because this will be a formal resolution. I think we can send it to the EPA. I think we can send it to the Environment Office, Pennsylvania DEP. I think we can send it to Valley Sanitary Authority and Dallas Area Municipal Authority. Let them know that we're serious about this. We're willing to work with them to help get resolution for the people. But at the same time, this is a serious matter. It requires real action. And you can see, obviously, we had 100 people come out tonight. This is a real serious issue that the people they've just had enough of it. And I think we all got the message. So thank you, everybody. We got the message. Thank you for everybody out there, too. But I think if we could do that, I think it would be just very appropriate. But I'm willing to debate it. But I can put those changes in there. I'd gladly submit it for the next voting session. But I'm open for
Anyone
discussion,
else?
too.
Yeah, Mr. Griffin.
I appreciate the information Harry gave us on that, and that was exactly what the purpose of the resolution was, and that's why I put in hereby authorized to seek an injunction. And that gives the Office of Law the ability to proceed, because the charter says that the Office of Law can't do anything unless council gives them the power
That's right.
to initiate litigation. So that was the whole point of the wording, to say authorized, but I'm open to amend that to say seek information. The other question that I have is if the manager, or I'm sorry, not the manager, but the council chair could put on the agenda to give us an update on the codification.
On which?
Codification for the ordinances for the next meeting. Also, we really need to have the ACE Commission chair come to this body and give us a report of the ACE Commission. That hasn't been done in 2 years, probably.
I think he
So
did
we
do
need to
a
have him
report,
come.
but I'll have to check on that.
Mark Dixon, I believe, is the chair of that
Mr.
committee.
Dixon is the chair of that.
So we need to schedule that into a work session if the chair would do that. And also the public hearing before the PennDOT was coming next, I think PennDOT's coming on the 11th, correct?
That is the scheduled date.
So we had a public hearing today with, obviously, at 5:45, and PennDOT hasn't given us any information that the public could have used at that meeting. So I would, and I know I spoke to you, Mr. McGinley, about that, and you said you'd be happy to put another public meeting in if we need to.
If we
I
need
would
to
like
do
to make
that,
sure
we
that
can do
we
it.
do that before we vote on that ordinance by Mr. Urban, that we repeal that we give the public another opportunity to speak on the ordinance again after we get information from PennDOT, so that they would have that information to either support it or not support it. I think that would be very important. I think it's a little bit, I don't think it's appropriate to have a public hearing if we're gonna have PennDOT come, but I certainly appreciate the input that we got at the public hearing. So if we could make sure that that happens before we vote on Mr. Urban's ordinance to repeal that, that would be helpful. And the other thing that I have is the contracts for the $5 vehicle fee. Was there any contracts, was that bid, if the manager can ask? My question is, were those contracts bid for Pensy company that did the paving? Did we do a bid process, RFP for any of that, or did we just get a contractor and say, because I didn't see any RFPs out there?
The actual work?
For the actual work.
We bid them out.
Did you bid them out? Because I didn't see any contracts on the manager's page for any of the work that was out there, unless I missed it. I very well could have. But I didn't see any contracts for those expenditures. So it would be helpful to know that that actually was bid out and that we took care of it. So
I think
that's,
you got that reply, but he'll give you some document that
yeah,
shows
if you
that.
could just let me know that that's out there somewhere, I'll be happy with that. And I think that's the only notes that I have that I really wanted to talk about. I really would hope that Harry will schedule a legislative committee meeting as quickly as possible so we can get started on it. I'm sure he will, so.
We'll do it after 2 weeks, Walter, go on a voting session, then I'll authorize one. That'll be the number one item on the agenda.
Excellent, thank you.
Yep.
That's all I have, thank you, Mr. Chairman.
Anyone else? Motion adjourned.
So moved. Second.
Ms. Radel and Mr. Haas, all in favor? Thank you.